Greetings, y'all. Derek DeBrosse here, Ohio gun lawyer, munitionsgroup.com, munitionsgroup.com. I think I forgot to mention that in my last video. Well, y'all got my website information. Call us, email us. We're expanding rapidly. Anything under the sun regarding firearms or self-defense, we can help. Today's question comes from a Jeremy. Jeremy writes, I carry a S&W shield and it has a thumb safety. I just pulled out the sear and took out the safety. If I should use this gun in self-defense, would the removed safety potentially get me in trouble with the prosecutor? I don't think it's out of the realm of possibility, Jeremy. Do I think it's a huge concern? I'd have to really see exactly how your gun is configured, but I don't think it's a huge concern. I don't know that it's wise, in my opinion, it's not wise, in fact, to alter a stock firearm the way it's configured, especially when we're talking about the safety issues. I've done videos before where I know I don't have a huge concern with trigger jobs and lightening the trigger. I just don't think it's a big deal. And I have friends that work at BCI here in Ohio that do the testing, and my friends are prosecutors as well. And they don't test for trigger weight unless they're specifically asked by a prosecutor. And generally, prosecutors don't know much about guns, to be quite frank with you. Very few do, in my opinion. I have a couple friends that know a lot about guns that are prosecutors, but only a couple. So when they send it off to be tested, all they are testing for, at least in Ohio, is a bang. That's it. So the argument is kind of the same, that you're changing the weapon. There's nothing illegal inherently about that. Can the prosecutor draw attention to it to a jury? He could try. I think you have some arguments based on the evidence rules that it's not relevant. However, who knows, right? So why take the risk? I just don't like messing with the safety components of the firearm because if it does come in, the jury could start to perceive that as being reckless or even negligent, and there is such a thing as negligent or reckless homicide. So just keep that in mind. But generally, remember this. At the end of the day, here's the thing. If you acted in self-defense, it doesn't matter if you use a Kubotan, a machete, or whatever, or a bomb. As long as you meet the elements of self-defense, you meet the elements of self-defense. And in Ohio, remember, we have the burden as people acting in self-defense to prove to preponderance of the evidence to that jury or judge that I acted or we acted in self-defense. We have to prove that we didn't violate a duty to retreat. We have to prove that we didn't start the fight. And then most importantly, that we had an immediate, honest and reasonable belief. We had an honest, reasonable belief of immediate risk of death or great bodily harm. So, I can use my hands for bodily harm. I can use an unsafety gun like you. I can use a knife. I can use a machete. I can use a candlestick. My car. There's a lot of different ways we can use items around us to inflict deadly harm and justify deadly harm. So just keep that in mind as well. Never forget that. But my general recommendation is I don't think it's a great idea. There's other guns out there that don't have external safeties already, like the Glock. The Glock 19 is one of those. So maybe just try a different firearm, Jeremy. I think you're going to be in a better position than actually modifying the safety on your firearm. It's my understanding that the shield actually can be purchased with or without the thumb safety as well. So that's something to keep in mind. So my statements really apply as long as it's clear and factual and evident that you're the one who removed the safety. But I've been told that the shield is sold without that thumb safety already. I think that changes the argument a little bit because then I didn't remove it. That's just how it was sold, how it was designed to be used and functioned. That's different than the jury hearing that you removed the safety. You removing the safety doesn't impute any criminal liability in a vacuum in and of itself standing alone, but the jury will hear it, and to people who don't know anything about guns or very little about guns, to me as an attorney, it's not an issue I want to deal with. I think it's going to cause red flags to the jury. Again, they might just perceive you as being reckless or negligent, and it's not a fact that I think you should have to deal with because I think you have better options out there than removing components of a firearm. There's other firearms you can buy. And again, I know my argument on trigger jobs, it seems to contradict this, but it's a slight nuance. Remember, trigger jobs are different than removing a safety component. I just don't think the trigger job issue, lightning and trigger, is as big of a problem as some people in the community make it out to be. I just don't think it is. I've never seen it in my practice come up. I've asked my prosecutor friends about it. It doesn't come up to them either. It just hasn't. I'm not saying it never comes up. I've never seen it. It's not as frequent of a problem as I think a lot of people lead others to believe. So I hope that answers your question again. As always, remember to be safe and carry on.